button?
It's hit.
Oh, there I can. Oh, I do see that. Okay, cool. Well, thank you, Ryan, for that. My name is Todd Lyden. I'm the Small Business Center Director at Bladen Community College. We're having legal liability of owning a small business webinar today. I'll introduce our speaker in just a second, but let me tell you real quickly about myself and the Small Business Centers. We are one of 58 throughout the community college system in the United States or North Carolina here. We offer these no-cost seminars and webinars and one-on-one counseling. We're here at Bladen Community College, but if you drive about 40 minutes in one direction, you should hit one of the community colleges where they have these types of no-cost seminars all the time. We're starting to do more of these webinars, so if you're interested, please look us up and join us. Here's some of our impact from last year. You see we're #1 for providing these types of seminars, but we also do help folks start and retain jobs and start businesses. And you can see, I don't know why we're only impacting 90 of the 100 counties, but I think that's pretty good. And our presenter today is Mr. Rhyan Breen. He'll do a little more formal introduction, but he'll be back with us again on July 18th to discuss nonprofit formation. Right, Ryan?
That's correct.
Sounds about right. Same time, same bat channel here at 1:30. And Ryan, you got your presentation all lined up?
I'm ready.
All right. Well, I'll let you take over.
Thank you much.
Here we go.
Let's start from the beginning. Like Mr. Lyden said, my name is Rhyan Breen. I'm an attorney at Farris in Wilson, North Carolina. I've been practicing law for the past 8 years. My practice is primarily criminal defense, but I also do a lot of small business formation. I do a lot of civil plaintiffs work, and a little bit, I just started dabbling this year in some civil defense work. But what we're going to talk about today is the legal liability of owning a small business. And really what I'm going to do is just give you a overview of contracts, agency, and premises liability. The first thing we're going to talk about is contracts. And I'm sure most of you are familiar with contracts. A lot of times they're memorialized with a handshake, but you need to know that a handshake in this day and time is not necessarily enough for a contract to hold up. There are several different types of contracts that you'll encounter during the course of running your small business. You have contracts for services, contracts for goods, buy-sell agreements, covenants not to compete. Those come into play if you have an employee and you're getting ready to sever the employee. Typically, covenants not to compete are signed at the beginning of the employment relationship as opposed to the end, but that's another type of contract you need to consider. And the last and probably most often is a lease agreement if you're just getting started. So what is a contract? A contract is essentially an agreement between two or more parties, and one party promises to provide a good or perform a service, and they do it for valuable consideration. And it really helps if everybody that is a party to the contract is competent and if the agreement is reduced to writing. That is something I'm probably going to harp on, and you're going to hear me say several times throughout the course of this presentation, is make sure you get things in writing. A contract is an agreement. As you can see from our friends here in the cartoon, somebody's going in for a high five, somebody's going in for a fist bump, and then you get yourself a flump. You can tell that there's no agreement between the parties because of how awkward it looks when the two hands come together. The agreement in and of itself has two parts. There has to be an offer by one party and acceptance by the other. An offer is just a promise to do or refrain from doing something. So a promise to provide a service or not to provide a service, or to, in the context like I mentioned earlier, like something like a covenant not to compete, or to provide a good. The acceptance has to be unambiguous, which means the person has to tell you or has to declare their assent to the offer. If the acceptance isn't the same as the offer, it's a counteroffer, and the counteroffer has to be accepted exactly. So for example, if you go to the grocery store, you get a loaf of bread priced $1.99, and you take it to the counter and you tell the person at the counter, I would like to purchase this bread but I will only give you $1 for it. Other than the awkward look that you'll get from the cashier, unless they accept the price that you gave exactly on those terms, you're not going to be able to buy the loaf of bread. And to that end, there has to be a meeting of the minds, and a meeting of the minds is just like, think back to that flump graphic where somebody was given the high five and the other person went for a fist bump. There has to be a basic understanding of what the substance of the contract is and what the terms of the contract are. So let's go through some hypotheticals. I think that's probably one of the easiest ways to learn about these elements. So let's just start with whether or not there's an agreement. Push mower Patrick shows up on your doorstep and says he'll mow your grass for $40, and you agree to let him do that. Do you think there's an agreement? The answer, obviously yes. So what if push mower Patrick shows up on your doorstep while you're gone and just starts mowing your grass, and then later he sends you an invoice for $40? Did you agree for push mower Patrick to mow your grass for $40? Absolutely not. There's no meeting of the minds. He undertook to do it himself. There's no agreement between the parties. There's no agreement. There's no contract. Then push mower Patrick comes to your house. He says he'll mow your grass for $40. You say you'll pay him $20. He mows your grass. You give him the $20, and then later he sends you an invoice for $20. Are you obligated to pay that additional $20? The answer to that question is no. He made an offer. You didn't accept his offer. You did a counter offer of $20. He evidenced his acceptance of that offer by mowing your grass. And like I was saying, once he typically starts the action, he accepted the counter offer of $20. To provide a good or a service, which is the next part of a contract, this one is pretty much exactly how it sounds. But just to break it down a little bit for you, goods are things you can touch, feel, and use. They're like the bread in the first example, cars, computers, things like that. Services are actions provided by an individual or a group of individuals for valuable consideration. So consultation agreements, hiring somebody to perform work on your house, contractors, things like that. Those are all examples of services. We encounter these things during the course of our everyday lives, and whether or not we realize it or not, we often engage in contracts without even knowing that we're a party to, without realizing that the actions that we're engaged in is contractual in nature. For valuable consideration is the last part of a contract. Consideration is something of value promised in exchange for specific action or non-action or providing a good. Examples of that include money, exchanges of services, bartering, things like that. Oftentimes in my practice, I'll encounter people who aren't necessarily able to pay, but they are particularly skilled in something. So I'll get them to come mow my grass, do a little work around the office in exchange for my legal expertise. But this consideration, this valuable consideration, is essentially what distinguishes your contractual arrangement from a gift. If somebody just comes to mows your grass like push mower Patrick did in the second hypothetical where he just showed up and mowed your grass, that providing a service by push mower Patrick is a gift from him. Competency, like I noted early on, it really helps if both parties or to the contract are competent. A natural person is only liable for the duties he or she agrees to undertake unless the person is a minor, mentally incapacitated, or intoxicated. Minors in North Carolina generally can enter into contracts, but only for things that are necessities. That's called the doctrine of necessaries, and it covers things like food and clothing, and depending on whether or not they're emancipated, which means whether or not they no longer have a parent or legal guardian or custodian, they can enter into contracts for things like lodging. Mentally incapacitated covers people who, just to use not an obscure example, but in the most broad sense of the terms, people who are in a coma, people who can't act for themselves, people who they lack the ability to understand the proceedings around them, people that require guardians. Those are people that are mentally incapacitated, and unless they have an appointed guardian of some kind, they can't enter into contracts, or contracts can't be entered into on their behalf. The last part is intoxicated. You've heard of not driving while drunk. Please don't contract while drunk. The agreements you make, unless you can show that you were intoxicated while you were drinking, that are enforceable unless you can show that you were intoxicated or otherwise not competent to enter into the contract. Think about Mad Men and all those deals that went down during the course of that show. Mad Men was a show on AMC that took place in the 60s, where most of the deals went on while everybody was drinking or at a bar. However, a majority of the time, in modernity and where we are now, if a party is intoxicated, it's highly likely that that contract will end up becoming void as a result of the lack of competency of that person. Writing, like I said, oral agreements, and I'll talk more about oral agreements later, but in the best case scenario, all contracts are eventually reduced to writing. There are some circumstances where contracts must be reduced to writing, and that's in North Carolina, and that's typically by statute. Very broadly, we call that the statute of frauds, but there are other statutory provisions that allow or that require things to be in writing, like sales of real property, interest in land, including easements. But just to go over what kind of contracts must be reduced to writing, sales of goods for an item over $500, any kind of sale between merchants, if within a reasonable time, a writing and confirmation of contract and sufficient against the sender is received and the party receiving understands and does not object to its contents within 10 days. That's a really fancy way of describing a shipping contract. So if you ship 1,000 widgets to somebody and send the writing contemporaneously therewith, then they sign receiving it, and if they don't object to the condition of the widgets within the 10 days, that contract is essentially good. Like I mentioned earlier, the sale of real property and interest in land, leases longer than 3 years, that again is by statute. Suretyship, which is where one party guarantees performance of an obligation by another. Think of when you have to co-sign on a lease and essentially guarantee that the person that you're having to co-sign for will continue to pay the lease. In a suretyship agreement, once you guarantee that performance, typically you become on the hook for payment if the person defaults or doesn't perform under the lease agreement. And there are different categories where suretyship arises, but I think that's the easiest one to explain. Covenants not to compete, like I talked about earlier, where you get a employee for valuable consideration to agree not to compete in a certain space for valuable consideration. Any kind of promise by the executor of an estate to pay debts out of his own pockets. And lastly, marriage. Oral agreements, like I said, they are enforceable as long as they are not required to be in writing by statute, which is everything I just talked about a second ago. But they have to meet the rest of the requirements for a contract, which means there has to be an offer and acceptance. You have to provide a good or a service, and that has to be done for valuable consideration. If you don't have any of those elements, then the oral agreement will fail. But just as a tip, please document everything. Of course, when one party performs and the other one doesn't, or the parties can't agree on how things need to be performed, there's a breach of contract. Breaches of contract are when a valid contract exists, one of the parties did not perform pursuant to the agreement, the contract was not modified at any point, and the thing that the party did not do is a material breach. Then you have an actionable breach of contract. I want you guys to consider material breaches versus minor breaches. You really shouldn't sweat the small stuff. A material breach is a substantial departure from what was contracted for, and there are factors that the courts consider in determining whether or not there is a material breach. They think about the amount of the benefit received by the non-breaching party, whether the non-breaching party can be compensated for the damages, the performance performed by the breaching party, hardship to the breaching party, negligent or willful behavior of the breaching party, and the likelihood the breaching party will perform the remainder of the contract. So for example, let's say you have 1,000 widgets and you have to get your widgets from Turkey or Syria or some other relatively unstable part of the world. If you get 80 of those widgets, or if you get 100 of those widgets rather than 1,000 of those widgets, the court will consider whether or not the amount of benefit that was received by the non-breaching party. And if you're able to, and if you can't receive those widgets or provide those widgets because that area of the world suddenly becomes unstable, then the courts consider the hardship in trying to replace those specific widgets that you were getting from that unstable part. But of course, if you didn't provide the widgets because you just forgot or because you didn't want to, that very obviously is a breach. Pro tip, coming from a lawyer's point of view, litigating any kind of minor breach of contract, it takes your time and your money. If you decide to bring something to court, you have to make sure it's worth everybody's time, especially your own. People don't talk about it, but judges are people the same way. The same kind of people we are. They don't like to have their time wasted. And I've seen a lot of folks who have been in breach of the contract get their claims thrown out, or they're given just a very small sum of what they're asking because the breach of contract before the judge is a very small breach and really isn't worth the court's time. There are a lot of defenses of breach of contract, for example, failure of consideration. So if you have those 1,000 widgets and the purchase price was $1,000 and that $1,000 check bounces, the person who bounced the check can't sue the person providing the widgets for the cost of those 1,000 widgets. Whether or not the contract was against public policy, I'll just circle back to covenants not to compete. A good example of that is if a covenant not to compete is for an extended period of time or takes a giant geographical area, the courts have generally considered stopping somebody from working in a field in a huge geographic area and over a long period of time is against public policy. And possibility, if two parties contract to colonize Jupiter within the next 10 years and the breaching party or the party not in breach sues the breaching party, the party that didn't get them to Jupiter after that 10-year period, it's likely that that contract is going to be tossed out because it was relatively impossible to get there in that time. Limits, any kind of contract that limits the amount of damages that can be recovered. So for example, again, going back to those 1,000 widgets, if somebody contracts to purchase 1,000 widgets, and in that contract it says you can only recover $1 if the widgets aren't sent, then that is a defense to the breach of contract. Any kind of illegal contract, you cannot take a hit out against your wife. Anything, you can't contract for the sale of illegal drugs. Any contract that was procured by fraud. Fraud is a situation where somebody essentially lies or does something to induce a party into entering the contract in the first place. If there's a unilateral mistake that was material and known to the other party, so if there's a typo on the contract and one of the parties knows that there's a mistake and fails to disclose that, that's a defense to breach of contract. Any kind of mutual mistake, so if both parties make a mistake, and that goes back to the heart of there not being any kind of meeting of the minds. And if the party has accepted the contract performance or a substitution, so if you were going to provide that 1,000 widgets, and instead of providing 1,000 widgets, you provided 800 widgets and 200 gadgets, and the party accepts the 800 widgets and the 200 gadgets, that's a defense to the breach of contract. And like we talked about earlier, the lack of capacity or the lack of competency. Lack of capacity works two ways. And we'll talk a little bit more about this in the agency context later, but somebody who's not a party to your business, unless you give them the express authorization to, cannot execute a contract on your behalf. And that is what is one of the ways we talk about lack of capacity. They did not have the ability to act. And the other way is lack of actual mental capacity or lack of competency to proceed. What kind of remedies can you get for a breach of contract? A court absolutely will not make a person perform. We abolished slavery quite some time ago in the United States, and a court will not make somebody perform a contract or labor. So typically the kinds of damages you can get are compensatory damages. Punitive damages, even though it breaks your heart when a contract is not fulfilled, are typically only available in cases that involve fraud. And then there are treble damages. Treble means 3 times the damages for violations of the Unfair and Deceptive Trade Practices Act. The Unfair and Deceptive Trade Practices Act comes into play when the actions of the parties are of or affecting commerce, which is a really fancy way of saying goods or things that put things into the stream of commerce. That sort of feeds into the Uniform Commercial Code, and I'll just very briefly tell you what that is. The Uniform Commercial Code was adopted by North Carolina. Pretty much every state has adopted the Uniform Commercial Code, and there's a federal Uniform Commercial Code. And its purpose is to simplify, clarify, and modernize the law governing commercial transaction. And it applies when goods are sold in a commercial setting. So purchases from merchant and merchant-to-merchant purchases. So when you go buy something from Best Buy, the UCC applies, or the Uniform Commercial Code applies. If you're a merchant buying something from another merchant, if it's 1,000 widgets that are being produced, being sold to a distributor, a widget distributor, then the UCC applies. Agency really refers to employees and people that you give authorization to act on your behalf. And we're going to talk about one of the most magnificent movies to come out in modernity, and that's Roadhouse. Agency, like I said, an agent is a person that has or appears to be acting on the authority of the principal, so in y'all's case, the owner or the employer. And it typically arises from an employee-employer relationship. I put the word typically in there because sometimes you're able to give an agent authority to act on your behalf. And when you give an agent the authority to act on your behalf, you become liable for the acts of your agent. In the broad sense, what this is referred to and the legal avenue of recovery or the legal doctrine that makes the employer liable for the employee or the agent is called Respondeat Superior, which is a Latin phrase that means let the master answer. It's a legal doctrine by which an employer or other principal is held liable for any tort committed by the agent or employee while acting in the scope of their employment. It's typically triggered when an act was expressly authorized by the employer, when the act was committed within the scope of employment and in furtherance of the defendant employer's business, or the act was authorized by the defendant employer. The best case I can think of to illustrate this is a North Carolina Supreme Court case that came out in 1937. A fellow named Joe Snow, which oddly enough is his real name, went to the train station to pick up a buddy from that train station, and he encountered Sidnor DeButts, who was the general manager of the Atlantic and Yadkin Railway Company. The two got into an disagreement, a fight broke out, and DeButts ended up beating up Joe Snow. The case went to trial, and DeButts was found liable for assaulting Joe Snow. But then the jury turned around and found out that even though DeButts beat up Joe Snow, that he was acting within the scope of his employment with the Atlantic and Yadkin Railway, which is why the trial court's decision ended up getting appealed up. So was the jury right? Sort of gave you a little hint to that. Absolutely not. The jury was wrong. The court in that case held that liability only exists as against the employer for wrongful or negligent acts of his servant only when the agent is acting within the scope of his employment and is about his master's business, attempting to do what he was employed to do. So Sidnor DeButz was not employed to beat up people he got into disagreements with at the train station. He was hired to be the general manager of that railway. And that brings us to Roadhouse. I like using Roadhouse because everybody thinks about, what, or at least when I was in law school, one of the questions we had, because we ended up going to bars probably more often than we should have, was what kind of liability the people there had for us or to us. So in that movie, if you haven't seen it, which you should, Dalton is hired as cooler at the Double Deuce. He was hired by a man named Tillman. Tillman was the owner, to provide security and to clean up the Double Deuce. And during the course of the movie, he engages in several bar fights inside of the Double Deuce. So the question in this set of hypotheticals is, does the owner of the Double Deuce have liability for injuries from fights that occur in the Double Deuce? Yes, he absolutely does. He authorized Dalton to act in that capacity and sanctioned him essentially cleaning up that area by force. The movie ends with Dalton driving his car through the house of the antagonist, so a guy named Wesley, and he ends up beating up Wesley's henchman, and he ends up ripping out the throat of one of the henchmen. Is the owner of the Double Deuce liable for Dalton's actions that occur off the premises? No, he absolutely is not, because none of those are in furtherance of his employer's goal, which was to clean up the Double Deuce. Stopping Wesley from continuing to extort the town was outside of the scope of his employment with the owner of the Double Deuce. But Respondeat Superior typically isn't all roadhouse and fist fights at the train station. Typically, in my job, the way I see Respondeat Superior, it occurs in the context of motor vehicle actions. So if you own a vehicle, a company truck, a company vehicle, and one of your employees crashes that vehicle or hits somebody or does some sort of negligent act in the vehicle, the liability for that action ends up coming back on you as the employer. I've also seen an influx recently of Respondeat Superior cases where fraud is alleged by an employee. So most recently I've seen it in the North Carolina Business Court as somebody who hired one of their sons to act in a financial capacity, in a fiduciary capacity, managing retirement funds, and that employee was essentially siphoning those funds and padding his own pockets. The court ended up finding that because the employer had some knowledge, or should have had some knowledge, of what his employee was doing, that he was on the hook for the actions by his employee son. Hold on one second. But the main thing is keep an eye as best you can on your employees. Sorry about that. Somebody brought a baby to the office. But that leads us to premises liability. All landowners have a duty of care to all the lawful visitors of the premises. The duty is a duty of reasonable care to protect any lawful visitor from injury. Examples of that include cleaning up after a spill, providing adequate security, and things like that. A landowner has to have knowledge of the condition, and if the condition cannot be corrected, then you have to give a warning that that condition exists. Premises liability cases typically fall into three sets of cases. The first is slip and fall. Those are the ones you hear about most often: somebody falling in the Walmart, somebody slipping at the store. And the issue is typically how long the dangerous condition was present, and whether or not the person or the employer or building owner had knowledge that the dangerous condition was present. Property defects and improper maintenance, that comes comes into play when there are deck collapses, any kind of broken stairs, any kind of falling walls, things like that. So if you own rental property, if you own or lease a building and you notice that it is in disrepair, you have a duty, an affirmative duty to try to keep that building properly maintained. And the last is inadequate security. You have a duty to provide adequate security measures, especially when prior crimes have occurred at a particular location. So everybody's favorite game is the employer liable? Here's another set of hypotheticals involving Anna's Autos. An employee for Anna's Autos spills a soda on the showroom floor and doesn't clean it up. Several customers mention the spill. Jessica walks in off the street, slips on the soda, and is injured. Is the owner liable? Yes. They had knowledge. The soda just sat there. It never got cleaned up. Somebody came in off the street, slipped and fell. The owner of the business is liable. Anna's Autos has small depressions, and by that I mean 3 to 4 inch dips in the sidewalk. Anna's Autos knows about the depressions. Anna's Autos does not warn anyone about the depressions, and then poor Jessica loses her balance in the depression, falls and hurts herself. Is the owner liable? No, according to the Court of Appeals. They've held that trivial depressions like 3 to 4 inch dips aren't enough to give rise to any liability for an owner. And then when you enter through the threshold of Anna's Autos showroom to the hallway to the bathrooms, there's a 6 inch drop off between the showroom and the hallway. Jessica, bless her heart, doesn't notice and hurts her ankle. Is the owner liable? Yes. And just very briefly on that, that's why you see the tape and the notice and the caution, floor drop or uneven floor signs when you go places. If it's not readily observable that there's a drop off and somebody falls as a result of the drop off, then that person or that owner becomes liable for whatever injuries result. Anna's Autos has a weak spot in the floor. They've noticed the weak spot for quite some time. It creaks more and more every time they walk over it. Jessica, again, bless her heart, walks onto the weak spot and falls right through that hole. Is the owner liable? Yes. Jessica, they didn't give a warning. They didn't attempt to repair the hole. They had noticed that there was a weak spot in the floor and didn't do anything about it. They undertook no duty to correct. That owner is liable for the injuries of Jessica. And then this one, I used some neighborhoods because I didn't want to offend anybody in a fake town. But let's say Anna's Autos is located in the Chamberlain Hills neighborhood in San Andreas. Chamberlain Hills is a known high crime area with a lot of gang activity. And then even though Anna's Autos is always open after dark, it doesn't install any kind of security lights on the property. And while they're open, Jessica is robbed while walking on the lot looking for a car. Is Anna's Autos liable? Yes. It's a high crime area with a lot of gang activity. If they know or have a reason to know that there's a propensity for any kind of robbery or crime, they're liable for not taking any kind of action to deter that crime or otherwise protect the people on the property. An employee for Anna's Autos is eating lunch and leaves a banana peel on the floor. Jessica slips and falls on the banana peel. Is the owner liable? Not in North Carolina. Just like with the depressions, not like the depressions, but North Carolina is what we call a contributory negligence jurisdiction. And people on your premises have a duty to watch where they're going. Contributory negligence means that if a person can be shown to even be one part at fault or they were acting negligently themselves, then that person who was injured as a result of their own negligence, even though it's not the big reason for their injury, that person can have and recover nothing as a result of their own negligence. So just some tips and things to think about going forward. Reduce as much as you can to writing. This protects you, this protects other folks. Write down, take copious notes about the transactions you're engaging with. Keep as much records as you can, as many records as you can. Save your emails. In this day and time, people fire off offers, counter offers, changes to contracts and what they want and things like that. You need to save your email so that way you can show all the offers, whether or not there is an acceptance, any kind of counter offer, and then that can help describe the contractual arrangement between the two parties. Next, keep an eye on your employees. What you don't want to happen is get into a situation where they're doing stuff or undertaking a course of conduct that you don't agree with that may be outside of the scope of their employment, or they're doing things that they believe are actually helping your business but actually are not. If it's outside of the scope of their employment, or it's something or a business practice you don't agree with, make sure you document it and discipline that person if necessary, because if they continue on that course of conduct and you previously said that you don't agree with it and you know that, and they know it's not what we call ratified or sanctioned by the employer, then you're not going to be responsible for that employee's actions because you have previously told them not to act that way. The one small caveat to that is if a person continues to undertake a pattern of conduct that you don't agree with, or that it could potentially harm somebody, either monetarily or physically, there's a tort in North Carolina called negligent retention or negligent supervision, and if you don't take action to remedy that that conduct by your employee, you may be held liable for continuing to retain that employee or not otherwise properly supervising that employee. And the last tip to avoid liability for your small business is make sure you walk your property at least on some kind of regular basis. Make sure you keep a clean work area. Make sure you always have employees that are constantly patrolling. Constantly patrolling your place of business to make sure there aren't any kind of noticeable defects, and if there are, make sure that your customers are aware and make sure that they are ultimately corrected. I talked about this the last time I gave one of these seminars, but please, and I didn't write it down, but this kind of goes without saying, but I have to say it anyway, please get insurance. Get insurance for whatever kind of business you're in that covers those actions. Get premises liability insurance, and then if you can afford it, get an umbrella policy that'll cover anything else that you may be forgetting. Consult with a local insurance agent about what your particular insurance needs may be. I think, is there a question? Oh, it just says if you have questions, use the chat. But at this time, if there are questions, I'd be happy to open up the floor to questions. Again, my name is Rhyan Breen. I'm a lawyer at Farris & Farris. The question is, am I meaning personal liability insurance? I don't mean personal liability insurance. Hopefully, in the context of owning a small business, what you have done is you have incorporated your company or otherwise organized your business structure. So you're registered either as an LLC or as a C Corp or corporation to protect yourself from personal liability. If you're operating as an individual, if you're a sole proprietor, or if you're in a partnership, you may be able to get, I have professional liability insurance since I'm a marketing consultant. That's good. Denise Murphy said that she has professional liability insurance because she's a marketing consultant. That's good. And that's helpful. But again, if it's a business, hopefully and ideally, what you've done is incorporate to protect yourself from any kind of personal liability, and the insuring party would be the business as opposed to your personal self. But professional liability insurance is great. I've got professional liability insurance, even though I'm part of a firm. My wife has professional liability insurance because she's a nurse, and that's good stopgap insurance if for some reason you do something that is uncovered by the insurance coverage that you have through your company. Are there any other questions? Well, that is it. If you have any additional questions, please feel free to contact me at Rhyan@thefarrisfirm.com. That's Rhyan at how much is professional liability insurance usually? I don't know. It really depends on your profession and how much coverage you get. That's a question better suited for an insurance agent. And Denise, yeah. But those are all the questions. That's all I got. Have a great day.